Thank you so much, both. This question's for Jeremy, which is the American distaste for being under the competence of a standing international court. Is that distaste similarly the underpinning of American, at a constitutional level? Do you think their kind of reluctance to look at comparative constitutional law compared to most final courts of appeal, they're quite reluctant, and as I understand it, over the years they've become less open to using customary international law to help interpret provisions of the Constitution, whereas it used to be part of the Charming Betsy canon. Does a similar, are there similar impulses behind all of these things?
Sorry. I frequently have this experience with students, which is, I'm not saying you're a student, but I mean, it's like someone asks me a global question, like, do you think the history of the West has been upward? Like, you're asking a real big question. I do think it is somewhat related to this important fact that is the American hesitation about these things. It's a very important fact which I think is not well understood outside the United States. And that is we adopted a constitution in 1789 that is still our constitution. There have been a number of amendments. Most of them haven't been very important. So there have been some important changes in practice, of course, but it is an entirely common thing. And it's not just among right-wing antiquarians or Burkeans. It's people on the left do this just as well. Like, here's my argument, the Constitution must mean this. It says so in the Federalist Papers. Number 71 is just exactly on point. That was published in 1788. I think there is not another country in the world where people are quite so confident about dredging up something from the 18th century and saying, like, that's it. So if you have a lot of reverence for the Constitution as something like really special and enduring, then you're like a little bit nervous about international commitments which will have the effect of either undermining it or altering it. I'll just give you one example that I think is somewhat to the point. If I remember this right, both in France and Germany and maybe in some other countries, constitutional courts said, actually, domestic constitutional courts said, this international criminal court is actually a problem because it could subject our nationals to criminal process outside the guarantees in our national constitution. So actually that is kind of a problem. And the same kind of arguments were made in the United States. We can't participate in this because it would mean we'd have to relinquish American citizens to be tried without the procedural protections of the Bill of Rights, so we can't do this. In Europe, the response was, oh, the Constitution stands in the way. Never mind, just change the Constitution. And they very quickly changed the Constitution, which they do all the time very readily. As I said, I'm not here to criticize, but I mean, this is a very different view of what a Constitution is. So if you just acknowledge that, in the United States, I think the Constitution is like constitutive, you know? It's solemn, it's a real commitment, it's really important. Let me just mention this, it might sound frivolous, but the National Archives of the United States have the Constitution, the original text, and they're in this glass case, and there's xenon gas or something to like preserve it. Like, okay, anyone could do that. But when they finished building the National Archives building in the 1930s, they thought that'll be great, we'll display it. In the 1950s, they looked up and they said, whoa, what if there's a nuclear attack on Washington? The Constitution might be lost. So they dug a sub basement and they put the constitutional thing, the glass thing, on tracks. So as soon as there's any indication of possible nuclear threat, it could be sent down 150 feet underground, everyone who lives in Washington might die, but the Constitution would be preserved. If that's your view of the Constitution, then you're not so ready to say, it's okay, we'll just like add to it, we'll just do it on the say-so of some foreigners because they know better, right? I mean, no. So, sorry, that's all right. Just one other quick thing about Charming Betsy. Justice Scalia, sort of I feel like the patron of our law school, said, that was okay to, what he's referring to is this doctrine that statutes should be interpreted to avoid conflict with international law. And Justice Scalia said, rightly, that was one thing when John Marshall said it in, whenever that was, in the very early 19th century, and he was thinking about a few norms like the law of the sea. It means something totally different if you think international human rights law is part of customary international law, and then you just like rewrite acts of Congress passed by the House, the Senate, and the President in accord with that Constitution that's ready to be preserved 150 feet down because it's so sacred. And then you say, oh yeah, that constitutional process, and also whatever someone out there happens to say about what human rights are. So Justice Scalia said that is an avulsive change in international law. I had to look it up too. Avulsive means like changing the course of a river. Right? And his position was no. If that's what you mean by international law, no, we're not going there. And I think there's likely to be always, or at least for the foreseeable future, a block of justices saying, no, thank you, let's not go there. We shouldn't rewrite our statutes to accord with what the European Court of Human Rights happens to think is international law.
Thank you very much. Professor Parau.
As to Jeremy, three thoughts occurred to me while listening to you. One, I predict that Biden will sign up to the new court, even if there is opposition to it. All kinds of things have been imposed under Biden that the majority of Americans don't want, not just what's happening on the southern border, but also other policies like the energy transition. What makes you think that Biden won't accept it? My second question, I predict that this new court would not work any better than WTO for the same reasons. Nations will resist it, even if they sign on to it, especially when the court starts to hand down judgments that are one-sided. And my third observation, the European Commission sounds more and more like Charles de Gaulle in the days when the French Empire was falling apart and he was still talking of grandeur. Isn't this the WTO through the back door? Is the Commission trying to sneak around the WTO failure through other means?
Let me start with the last point. In the late 1990s, after the WTO had been established, which didn't have any provisions about investment, the OECD said, we need a treaty about investment, and let's have like a single treaty which would clarify. Let's not have 3,000, but at that time there were 800 bilateral investment treaties. Each one could be a little bit different. So let's standardize this. Let's have one multilateral agreement on investment. And the French were among the original advocates. A great idea. That's a standard. So France really likes that. It's like the metric system. It should be like divisible by tens. That'd be perfect, orderly. Yes. And then people started saying, wait, what are you saying? You're saying like corporations can like sue us and complain about our laws? This would be terrible. Well, what are you talking about? And so there started to be a lot of opposition, and the whole thing finally collapsed because France said, we changed our mind. I mean, it's okay. There was a lot of controversy in America, but I think that what the European Commission is now saying is, okay, we couldn't formulate universal standards for protection of foreign investments. Let's just have the institution. Couldn't we agree on the institution? And then the details will follow, right? So this is like another way into this. And you're saying, well, like, won't it happen anyway? Because they, whoever they are, always do these things and they don't listen. I think probably they can put it over on the EU. Maybe they can. I don't think that Biden could just on his own say, I'm signing up to it. I think that it would have to be cast as a treaty and require 2/3 support in the Senate. And if he said no, because the thing that you have to do here, this is why it's like you can't just say it. there's 3,000 bilateral investment treaties out there. All these countries, including the United States, have signed the ICSID Convention, sponsored by the World Bank, about how they'll implement these things. So if you want to have this new institution, you have to have a formal treaty that supersedes all the existing treaties, which the T in BIT stands for treaty. And every one of the BITs that the United States is party to, they were endorsed by 2/3 of the Senate. So I think that Biden couldn't just say, never mind, I'm superseding all that, never mind the procedure that's specified there. Let's go to the new court based in, wherever it may be based, Strasbourg, maybe. There's probably room there. I think it would have to be submitted to the Senate so you could have a treaty to supersede the earlier treaties. And really, I think you won't get 2/3 of the Senate. I don't think you'd get a majority, but I definitely don't think you'd get 2/3 because there will be populists of the left and populists of the right, and they will both raise questions. And what I like about the current system, it's very decentralized, it's very diffuse, and so that means it's hard for populists to say, I hate. There's 3,000 bits. It's number 1,270. That's the one I really hate, right? It's just too diffuse, right? There's no focus for it. But there'd be a real focus for it if you say, let's have the court of international investment. So populists on the left will condemn it, populists on the right will condemn it, and you won't get 2/3 in the Senate. And it's like a real fair question, how useful is this if the United States is outside it? Because that's quite a lot of world investment flow. And China, it will be outside it. That's quite a lot of outsiders. And it starts to look like, as many things do, the EU talking to itself. And it has 27 languages, so it has a lot to say, but maybe people outside will not be that interested. It's always a successful talk when people are stupefied afterwards.
Thank you. This is also a question to Jeremy because we took quite a lot of it, Lénárd already, so I don't have a question to Lénárd right now. I'm not an expert of international law at all, but after your presentation I became a fan of arbitration, of course. But the question is whether there is a dark side of arbitration. Since I don't know exactly how it works, but I have an idea, and I know that your new field of expertise is AE and something like this, so the new technologies. Whether it is possible to cherry-picking legal experts by having a research supported by AE, these legal experts is biased in that way, so which means that it is not arbitration, it might be arbitrary how to pick a legal expert who will decide my cases, actually. Or is there any other dark side of this very interesting phenomenon?
So what I think is particularly good about arbitration for international disputes is it sort of lowers the weight of any one decision. I don't want to give you the idea that people who become arbitrators just say, I don't care about law, I'm just going to just figure out what's good and then just say it. And by the way, I mean, for important disputes, it's usually not one person. I mean, it's usually, that's the typical thing, because each side wants to appoint one. The typical thing is each side appoints one arbitrator, and then the two of them agree on a third. So you've got one that's your guy, and if you're the state, you pay attention to what have people done in past cases. So you want somebody who's congenial to you, right? And the guy on the other side, the investor, if you're talking about this, oh, what have they done in other cases? Now, typically what happens is the lawyers, I totally agree with what Lénárd said, international law has become toting up the precedents. This is true in arbitration as well. I mean, it's true. I don't think he made this absolutely clear. The statute of the International Court of Justice, I think this was partly American prompting, says the decisions of the International Court of Justice, the so-called World Court, will be binding on the parties only, and then only for that dispute. And that's telling you that it's a descendant of this. It actually is, in real life, really arbitration. It's in its statute. it's not a binding precedent, anything they say. It's just deciding that one case. But of course what happens is the lawyer's like, oh yeah, well, you said this last time, and then you said this the time before, and the time before, so here are all the precedents, so just do it again. And when they write an opinion, they try to present themselves as like, hey, we're not making it up for this case. We said it before, we said it before, we said it before. And if this happens in a whole range of arbitration situations, very much including these disputes about whether investors receive fair and equitable treatment and so on. They look at the previous cases. But you can say, as either a state or an investor, don't look at that one, that was an outlier. That was really kooky. And that was explained by very special circumstances. That was the beginning of the Iraq War. It was very unpopular. They were really distracted. Never mind that one, right? And you can say that with a totally straight face. You don't have to apologize because you are very likely talking to people who had nothing to do with that previous case because you're constantly rotating through different arbitrators. And they are happy to say, oh yeah, I know that guy, he's really kind of off it. So like, I'm not listening to him, it's fine, good, thank you for reminding me. Yes, he really overreacted to the Iraq War or whatever it was. So it's a little bit looser, and looser is good when you're talking about international. I say this to my students because I think it's true. International law started out as basically a diplomatic practice. It was bargaining state to state with arguments and discussions. You mentioned Green Hackworth. Green Hackworth is known to Americans as the editor for a considerable period of years. Digest of International Law, but what it actually is, Digest of International Law as understood by the United States. And he would like pick out all these things. We said this, they said that, but we refuted it. And most of it is not court decisions of any kind. It's like formal statements saying we agree to this and we don't agree to that. And we thought this was a really good thing to collect, to remind ourselves and the world, here's what we think it means, right? So it's diplomatic. It's sort of bargaining around what we hope is some background consensus that there's a lot of bargaining. The more you say, no, this should be determined authoritatively by a court, the more you are saying, this means what the court says it means. That's what it is. And I think that is, political scientists talk about this judicializing international law. And if you're an outsider, you might think like, what do you mean judicializing? I mean, if it's a law, of course it's judicialized. No, no, no. Actually, historically, international law had a much larger component of diplomatic negotiation and discussion. And the reason why I'm in favor of that is I don't think you're going to improve on that. I mean, states are, when you get right down to it, in a position to say, I'm not going along. So maybe you're better off accommodating that or acknowledging that or working through that because they're not just in really important matters. You can't rely on them to say, I better do this or else I'll go to jail, because you will not go to jail, right? So as a state. So you really need to have a system which is somewhat flexible, and that's, I think, the virtue of arbitration.
So, Jeremy, I was with you until the very end there, when it just occurred to me that, of course, one of the theoretical advantages, and probably practical ones too, of an international court is that it levels the playing field between states with very different power. What do you reckon about that?
Maybe you think that is a nice idea, but it's very fanciful. Like, we have this international court, it doesn't level the playing field. The United States is free to say, never mind, you said it, we're not listening. That's been our response to every decision of the International Court of Justice we don't like. Well, of course, we can do that. And smaller states are a little more cautious about doing that. It's not, I mean, I'm not trying to be sarcastic or cynical. It is a fact of our world that states are different in a whole lot of ways, including what resources they can use to defend their positions. And it's really fantastical. It's just like escapist to pretend, oh, we're going to do away with that by just having a treaty, and then they won't be able to do that. Of course they'll be able to do that. I mean, that's just how the world is. And so my answer is not, let's go back to the state of nature and the one who has the most aircraft carriers will win. That's not at all what I'm saying, and it is, of course, not like how even China behaves. There's a whole lot of competing considerations that you have as you work your way through the world. You'd like to have some friends, you'd like to have some trading partners, you'd like people to have some trust in you. There's a whole lot of reasons why you can't just say, I'm big and powerful, so you have to listen to me. Right? So you are most of the time going to be negotiating anyway, and in a lot of areas you're happy to have a settled rule, even if it's not exactly the one you want, but most countries agree with it, so like, okay. And I could give you a lot of examples of things the United States puts up with which it doesn't like, but it's like, okay, well, that's what we're doing, okay, fine. But it's not true that you can prevent countries from remembering that they really hate something that they hate and maneuvering out of it if it's really important to them. Let me just give one example that I think is the really, of course, the telling example, which is the UN Charter has outlawed resort to war. Really? Okay, it's outlawed resort to war except in self-defense. Do we agree what self-defense is? No, we do not. So shouldn't we have decisions of the International Court of Justice which authoritatively say what that is? And the answer is no, countries are not going to listen to that. Now, I think it's importantly true that the world is sort of paying attention, and it's somewhat burdensome to Russia that most people don't think Russia has a really good explanation of why they invaded Ukraine. But you can say whatever you want about the International Criminal Court. Putin is really going to be sorry. No, he isn't. So you need to think about, well, all right, what can we do? So you have to hope that you can persuade a country like India, this is really bad, come on now. Maybe you can't persuade China. You could persuade India. I think we are, in America, gratified that we've persuaded France, which doesn't happen that often. And it's not that easy to do. But this is diplomacy, right? And diplomacy has something to do with making arguments that are serious, but it's also in the background, look, there are going to be these consequences, right? But you can't just pretend that because you have a treaty and a lawyer interpreted it, even a lawyer who wears a robe, that countries don't remember that they have 12 aircraft carriers or a lot of cruise missiles or whatever they have that they could use, and others don't remember that actually we don't have those things, so we need friends, so we should stick with our friends and make excuses for our friends, right? There's a lot of things going on in the world other than the bullies bullying.
Consumption?
I wonder if I can just take Nigel's question a little further. Although elegantly put, your whole argument is in fact for a free-for-all. And you say that's fine because the world is the way it is, and one characteristic of the world is that some countries, like for example the United States, but that's not the only example, are very much more powerful than others. I actually question whether the United States can always get its way in this way, and whether in fact ultimately it may not have to recognize that a more cooperative attitude to things which, unlike human rights, which we talk about most of these things, can only be dealt with at the level of international agreement, namely international trade. In that context, I think that the United States may be making a very serious mistake, and it may not matter whether they're doing it for sentimental reasons or for reasons of realpolitik. Let me take an example that you yourself gave. The United States' rejection in 1913 of the idea of an international prize court. Now, at that time, the dominant naval power in the world was the British Navy. In 1914, Great Britain repudiated the laws relating to blockade, which had been embodied in the Hague Conventions some 15 or 20 years earlier, and it announced that it was going to conduct a distant blockade, which an international prize court would have been in a position to rule illegal. Now, the first and loudest howls came from the United States, which might perhaps have done better by accepting this proposal. An interesting example concerns international investment. The United States has for many years been the largest exporter of capital in the world. When you invest money in another person's country, you are not exercising power, you are making you're putting your assets at the mercy of that country. The biggest loser by any system or free-for-all in the context of international investment will be the United States. So I will venture a prediction of my own, which is not that Biden will sign up to the proposed multilateral treaty, but that sooner or later the United States will realize that no power on earth will benefit by simply throwing its weight about.
It's a little bit self-indulgent, but I do want to start with your first point, because I actually know a little bit about this. It's true that when Britain had these very aggressive blockade policies, the United States complained. Britain had a very, very good answer, which was, this is what you did in your Civil War. You announced this blockade of all the ports of the American South, even when you didn't have enough ships to actually enforce this. So who are you to complain? To which our response was, well, you would say that, but I was, well, but actually, as the Germans noticed, we didn't push back very hard because we were neutral, leaning towards Britain, and eventually became Britain's ally. So I don't think we would have wanted in 1915, by the way, it didn't start in 1914, it took them a while to work up to it. But after it was clear from the first few months that this wasn't going to be over quickly, I don't think we would have wanted an authoritative body to say this is exactly what they can and can't do, both because we ourselves were thinking we have a big navy, we might like to do blockades, and also we didn't really want to undermine Britain's policy at least too much. We were basically negotiating with Britain, don't push this too far, but we understand what you're doing. And I think that is a common situation, that you have some rights that you want to protect, but you also don't want this authoritatively settled because you're willing to sort of bargain and negotiate, and you actually prefer to have this remain somewhat shrouded in uncertainty because you're not certain yourself what you want to do or say in the next round. On your larger point, maybe. I can't say we're always going to be happy with everything happening in the world. As I said, I think there are things that we have accepted. We have accepted a lot of WTO decisions that we didn't like in the name of preserving the system. But I do think that you're sort of repeating your initial point, which is if you don't have the authoritative appellate body, then you don't have anything. And that is not our view. Our view is if you have panel decisions, which is what the WTO is, okay, we have to live with the panel decision. We have to abide by the decision of the panel, but not necessarily to take that as settled for the future. And I'm not sure you're right that, well, eventually we'll come to the point where there has to be a European Court of Justice for the world, and we have to submit to it. I think it's more likely to go the other way, that Europeans realize, wait, this court is way beyond something that could actually be sustained even in Europe. And I think probably Hungary will contribute to their enlightenment.
Of course.
Can I circle back to the arbitration question with just a small comment, if I can? Yes, I agree that arbitration is flexible. Arbitration is more apt to the horizontal nature of international law and how diplomatic negotiations usually evolve. Although we talked about the dark side, I wouldn't say the dark side, I would just point out some negative aspects, which concerns Central Europe and Central European countries too. One of the things that we expected from investment arbitrations when we signed up for this regime, and one of the promises of this regime was to inject coherence into a transnational business law, or transnational administrative law, or something similar. Since one of the functions of courts in international law is to provide coherence because there's no central legislation and so forth. But in reality, we rarely did get this coherence. And one prime example concerns the Czech Republic, and I think it's American investment. It was an American investment in the media sector of the Czech Republic, the popular television station TV Nova. Mr. Lauder, I think Rolf Lauder was the investor, and he established Ron Lauder. He established a company in Netherlands, And through that company, he invested in the Czech Republic. And what happened was a regulatory taking. Due to a media regulation, he lost his, some of the profitability of its station. And he initiated 2 parallel proceedings based on the same set of facts between 2 different investment tribunal, but organized on very similar treaties, the Dutch-Czech treaty and the US-Czech treaty. And surprisingly, the 2 tribunals handed down 2 very opposing decisions. One of them was in favor of the Czech Republic, defending its regulation, but the other one, I think the US-Czech treaty, the arbitration based on the US-Czech treaty went in favor of the investor, and the number, I'm not sure, it was over $300 million, which is equal to maybe the healthcare budget of the whole country. So maybe that's one negative side of arbitration, that it in spite of the expected coherence we would hope to inject, it's just not live up to this expectation.
I think this is, I mean, with respect, I've read this many places, people make this point. This is not unique to arbitration. I mean, it's more prevalent with arbitration. I mean, even when you have the same statute in the United States, it happens very commonly that judges in one part of the country, I'm speaking now about federal judges appointed by the President, confirmed by the Senate in accordance with that sacred document. On the West Coast, they say, oh, it means this, and in New England, they say, no, it means the opposite. And it frequently happens that the judges in the First Circuit in New England have read the Ninth Circuit opinion from California and say, that's totally wrong, you didn't understand this. This is like the bread and butter of the Supreme Court. They try to harmonize or decide, okay, New England was right, they were wrong. But this happens commonly. And it also happens commonly that the Supreme Court says, oh, there's a split among the circuits, never mind, we're busy, we don't want to get into that. Let's have a bunch of more litigation, and then we can have 4 or 5 or 6 cases that disagree with each other. That can happen with litigation, right? And you understate the complication here, because the example that I'm giving is the same statute just interpreted by different courts. But what happened in this case, louder, is these were different treaties, which are slightly different, right? And there's a trade-off here. There's something nice about uniformity. There's also something nice about saying, no, wait, I want to make a variation. And what's happening all the time, you're saying, you in your presentation said in 1990 they made this terrible decision which totally altered the meaning of it. Well, 80% of the bilateral investment treaties out there have been negotiated since 1990. So people were on warning like us. Someone said, by the someone is just like one arbitration panel said, is if you don't like it, Sri Lanka, you should renegotiate your treaties, which that happens routinely. So you can't just snap your fingers and have everyone agree to a new treaty, but you can, over time, replace the one that you now realize, oh, it's kind of vulnerable, and sort of fix this over time. But if you're allowing a lot of different countries to make a lot of different fixes, which, by the way, you could not do if you just had the one Supreme Court of investment for the world, just Superman and the multilateral investment court together guarding planet Earth. If you don't have that, well, okay, so you're going to have a lot of different treaties, and they're not going to fit exactly together. But people who like diversity should be comfortable with, okay, we have like a diversity of treaties, because diversity is, it's like along with equity and inclusion, it's one of the holy trinity of good things. Sorry, I didn't mean to put that on.
No. Well, my problem with that is that it's not an individual consent. And it's very unusual in international law. I think it's not only unusual, it's the only exception where a state makes, based on that judgment, a general consent to any kind of investor, and this is the example of the Lauder case, to any kind of investor who can prove that he's entitled to that protection. The state even doesn't know who that investor is.
I think this is true of any treaty, which is you don't know the circumstances in which it might apply. Like if you just have a treaty that says, like a trade treaty with 50 countries, so you don't actually know when you sign it. And by the way, let me say, it was the United States that pioneered like international trade agreements of indefinite duration. So we understood we couldn't just do everything on our own. We tried to negotiate this. But we didn't foresee in 1947, when we got the first version of this, that the Germans, damn it, would come up with this really popular car, the Volkswagen. We just didn't anticipate. And then suddenly they're flooding the American market with this car, which we hadn't known about. And if we had known about it, we wouldn't have agreed to let it come in under those rules. Well, sorry, that's called life. Right? This happens all the time. That happens even with bilateral contracts. You agree to something you hadn't anticipated that's, whoa, suddenly investors are going to make them much more powerful, but you still like lost with this, or you got a lot of extra money, so actually you don't want to be tied into this. Well, sorry, this happens. I think that's not like a general point. You might tell me in a specific situation this is a problem, and the answer to that is, great, that's why we have a very decentralized system that allows you to renegotiate so that you can have a workaround. But I think it's really fantastical to say, if only we all had the same rules enforced by the same court, then we would be happy, because everyone at least in Oceania, is happy together when Big Brother tells them you are happy. People are unhappy most of the time, right? That's part of life.
The last question goes to Professor Cliquenoir.
Yeah, thank you very much. Just a question to Lénárd, because I think there are really a dark side regarding arbitration. Regarding the courts as builders, do you think, I think it's more builder than geographer, or it could be both, but builders could also stick to plans and but regarding precisely the courts as builders, do they stick to a unique pattern, or this is constitutionalism as criticized by several scholars right now, or do you think that there is a diversity of patterns, of models that could be interesting, and depending on the context of jurisdictions, of countries, and so forth, and diversity of culture?
You refer to the bilateral investment treaties?
For instance, or there are other examples, but you could take these examples in particular.
My concern with bilateral investment treaty is that I mentioned the general consent, and based on the general consent, that opens the way to a general submission, and investors, wealthy individuals or transnational corporation can get with circumventing domestic courts and circumventing national jurisdiction, can get claim before an international arbitration, and it's just opening up the sovereignty, the sovereign regulatory choices, the economic governance of a state to unknown investors, and before arbitrators who really built up a law since the 1990s based on very flux and broad concepts such as indirect expropriation or fair and equitable treatment or other very broad terms. And since this is the only area of international law where the enforcement is reintroduced into the domestic level, and furthermore it's worldwide, pretty much worldwide enforcement, so you can enforce a judgment against Hungary in the US or in Croatia if you have a judgment. I see, yes, a so to speak constitutionalization. I wouldn't put it this way, but a judge-made law over sovereign regulatory choices that constrains unreasonably states. But in the past, I would say 10, 15 years, so since the Great Recession, since we see a backlash, we have seen a backlash against this system because unlike human rights, and as Peter Pacolai also highlighted, Strasbourg Court and Human Rights Court are just, if you compare international law to sand, stones and rocks, most of them are just sand. If the wind blows, it may blind you for a couple of seconds or a couple of minutes, but it doesn't hurt. But when it comes to WTO law, international law becomes a stone. It may hurt you, but usually it doesn't kill you. But if it becomes investment law, now that you arrive at the rock stage, and investment law can easily kill a country. I mean, not a mid-sized country, of course, but interestingly, what we have seen is it was very straightforward after the 1990s, in the 20-25 years, when we saw a one-way flow of foreign investments from west to east. But in the past 10-15 years, that flow sometimes reversed. So China appeared as an investor. India appeared as an investor. And the situation and the thinking has not been the same in Western European countries as well as in the United States. And that's partly the reason why I think NAFTA was replaced by USMCA, and why USMCA reintroduced the domestic remedies and customary international law between Canada and the US. And this is why we saw the ICS reform in the European within the European Union, and this is the same reason that I think it will never be operational, that court, because it's still too might be too risky for countries in Europe who used to be capital exporter countries, only capital exporter countries. But now they are also sitting on the other side of an arbitration panel. So that would be my answer.
I just want to clarify one thing that maybe hasn't been clarified sufficiently. When you lose an arbitration, you're at risk that the arbitration panel will say, this is the compensation you should give to the investor. The panel doesn't presume to say, now here's how you need to fix your law. Here's what you should be doing instead. It is totally focused on the investor suffered this loss, now you should compensate. So it is very much less intrusive, I would say, even than the Strasbourg court, although in principle the Strasbourg court is also focused on compensating the victim, but it's compensating the victim in the context of, here's what you ought to do, and this should be repeated. And it should be repeated with more and more devotion, because if you repeat it every day, it will improve you. The arbitrator goes home. I mean, they made their decision and then they're done, and then they're going back to making money in some other way. They're just saying you must pay this compensation. I take your point that there have been some awards which are really, really heavy for a small country. And my understanding of this, I mean, I have not made a close study of it, just like reading about it. What frequently happens in situations like that is they don't pay, or they don't pay the full amount. And so it's dragged out, and often someone who has won an arbitration award, it's too costly, time-consuming, difficult to try and collect the full amount, so they kind of settle on, okay, could you pay half of it, right? And I think people kind of, this is the kind of thing that gets to be known in the world of arbitration, that in certain circumstances, if you hand down an award which is too large, they're not going to be able to collect. And the arbitration panel itself is not at all like the Strasbourg court in, like, it's hovering there, making sure that it's implemented. They go away, they're done, it's over. They have no authority themselves to make sure that it's implemented. So you have to, as the investor, sue. And you have to figure out, like, what country should you sue? And do they have assets in that country? If you win an award in a country where the Slovakia or whoever it is has no assets, then you didn't get anything, right? And they can, of course, move their assets as soon as you show that you're going to try and pursue them there. So the country that is told to pay still has a lot of bargaining power. So I think it's, I mean, I do take your point. This can be really a painful surprise for a small country, that this could happen. But you should also look at the other side of it, which is, it's really nice to have foreign investment if you are a small country, because you can't generate enough capital on your own. And they bring not only resources, but expertise and connections. There are a lot of reasons why it's good to have foreign investment. If you don't want foreign investment, you don't have to have foreign investment. But if you want to have foreign investment, then you want to be able to say to foreign investors, you can trust us, it'll be okay. And you need to make that credible. And there's no better way of making it credible than saying, you know, we have signed a treaty with your country that if you feel that you've been abused, you can take this to arbitration. So that is an advantage for the host country to be able to attract foreign investment. And I didn't mention this, I absolutely should have in my talk. When we went from 500 bits in 1990 to 3,000 in 2015, the level of direct foreign investment didn't increase proportionally. It increased it was like, grew 12 times. And it's partly the era, the 1990s, people were optimistic, the early 21st century people were optimistic, but it's also, people felt more comfortable investing in a wider range of countries, and that is a good thing for the world. That is not something onerous that we're making small countries like, oh, we have to answer to arbitration. Otherwise, we'd be totally happy. We could just confiscate them and then enjoy the proceeds, and then life would be even happier because we'd have what we have and then what you used to have, and now we have it, right? That's not, no, the world is not like that, and you cannot make it go away by passing a law. So you need to bargain with foreign investors if you want to have them, and it's hard to make it credible. You just say, I promise, I'm really good. You know, we love you, love you, love you. No, that's not really very persuasive. So arbitration is a good compromise.
Yeah, I totally agree with you. We want to be the most attractive country for foreign investments around the world. I totally agree with it.
And that will just be a supplement to all the other ways that you are such an attractive country.
Yes. Thank you so much. Two slide questions. To me, it's questionable the correlation between attractiveness to foreign investments and the treaty, bilateral investment treaty. What is the correlation between the two? And the other thing is whether a contract and a contract-based arbitration, when the private investor makes the contract with the state, would be a much better fit to international law.
Yeah. So the second point, a lot of people bring this up, it's a fair point. Like Texaco made an agreement with Colonel Gaddafi, of all people, saying, you know, we don't actually want to improve your access to oil unless you promise not to expropriate us, because we noticed you did this to the previous people, BP or whoever they were. And he said, I won't do it. Here's a contract. So it wasn't a bit. It was just like Texaco and Gaddafi, and actually went to arbitration and you had to pay. So that's really great. It's particularly good if you're Texaco. What if you're just like a sort of mid-level company and you don't really have you don't have the leverage because you're not big enough to say sign a contract, and you actually don't want to like have to pursue all this on your own. So for smaller companies that are not Texaco, it's really helpful to have an infrastructure that's already in place. That's the point of the bits. And just on the, you want to attract foreign investment, is it really necessary to have the bit? There's a lot of dispute about this. What is the correlation? But I just want to remind people that we have spent, whatever it is now, 50 years, like urging everyone to have to sign human rights agreements or human rights conventions. You have to, you have to, you have to. What's the correlation between signing a human rights convention and actually treating human beings decently? And this has been extensively studied, and most people who have studied it said it's either there is no correlation or it's inverse, it's negative. Which you first think, which at first you think, but that can't be right. Of course it's right. Saudi Arabia is a proud party to the Convention against all forms of discrimination against women. How could they do that? Easy. No one says, I cut it out, that's in bad faith, you didn't mean that. What do you mean? We signed, don't you? Well, you can't read Arabic, but it says, it's our name. It says Saudi Arabia there, so we're in. Now you actually can object to this as other parties, and there were 2 countries in the world that said, wait, that's in bad faith. No, we don't accept that you have really committed to this. And they were, if I remember rightly, Sweden and I think Norway, Denmark, anyway, 2 Scandinavian countries, and the Saudis just said, okay, that's your opinion, never mind. And nobody else objected. And so it's very easy for there to be an inverse correlation, because when we ask people to sign a human rights convention, what we're really saying, a UN human rights convention, is, would you promise to be nice? And all over the world, dictators say, totally, I promise, yes. Right? So that's completely meaningless. But yet, people don't say, you know what, we need to rethink this, it's empty and silly. So I'm not myself saying, let's repudiate international human rights conventions, they're mostly harmless. But if you ask me, does the bit convey something important to investors, I think likely it does. Because what you're saying is not just, I promise to be nice, but I'm willing to have you come after me and demand compensation. And I'm willing, as a host country, to make this promise, even though I see Slovakia was crushed. Right? A lot of other countries are stuck with a big bill, but I'm still willing. So that's kind of compelling. That's something that is persuasive to investors, and I think everyone should aspire to reassure investors if they want to attract investment. That's like one of those basic principles of life. If you want investment, reassure investors, and you can have a good life. You might not be happy, but you'll feel like you have behaved honestly, and there's certain satisfaction in that, and you might get a lot of investment.
Thank you very much for the excellent questions and marvelous answers.